everyone, my name is Sushri Das and I am here today to guide you regarding patent revocation. So let's begin. Firstly, let's get an overview of patent revocation. Patent revocation means cancellation of the rights given to an individual by the grant of patent. A patent can be revoked on a petition of any individual interested or the central government or the counterclaim of the infringement suit of the patent by the High Court. The court may revoke a patent on the petition filed by the government if the High Court is satisfied that the patent owner has without cause failed to comply with the central government's request to use, make or exercise the patented invention for the purpose of the government upon reasonable terms. The notice of any petition for patent revocation shall be served on all individuals appearing from the registrar to the owners of the patent or to have shares or interests therein. Firstly, let's get a grasp on the essential basic concept, that is, what is a patent? A patent provides the original inventor with the protection against the illegal use of a new product or technology which is subject matter of the particular patent. The patent must be new, which means it is not published or used or is not known to any individual working in that particular area. This protection for registered patents is for a limited period. Now, who can file a petition for patent revocation? Firstly, the central government, and secondly, the person or individual who is making the counterclaim of the patent infringement in a suit. Where can a petition for patent revocation be filed? A petition for the patent revocation should be filed in IEAB, Intellectual Property Appellate Board, by any of the individuals under Section 64 of the Patent Act 1970. Section 104 of the Patent Act provides the jurisdiction feature for filing out a petition for patent revocation. Section 104 of the Patent Act states that the revocation of the patent claiming patent infringement shouldn't be filed in any court which is inferior to district court, giving the jurisdiction to try the infringement case. On the other side, in case of a counterclaim is filed for the patent revocation made by the defendant, such counterclaim or case of patent infringement should be transferred to the High Court. Now, finally, I am going to analyze the grounds of patent revocation. To counterclaim or disagree, one must have grounds on which he or she can reply. The Patent Act of 1970 provides some grounds on which the proposed individual can file a petition under the IPAB, Intellectual Property Appellate Board, or can file as a counterclaim in a suit for an infringement in the High Court. Section 64, which states the revocation of patents. The following grounds of patent revocation fall under Section 64 of the Patents Act 1970. 1. If the patent right has already safeguarded a similar invention with an earlier filing date. 2. If the invention fails to give the services as specified in its specification while applying for a patent registration. 3. The patent can be revoked if issued to an individual who is not entitled under the Patents Act. 4. If an individual provided with the patent is not an actual owner and has by misrepresentation or fraud obtained the patent protection of the actual owner, can look into the remedy of the patent revocation. 5. According to Section 8 of the Patents Act 1970, the inventor is bound to reveal all details required by the section. If such an inventor misrepresents or fails any of the asked details, the patent shall be revoked. 6. As per the Section 35 of the Act, the controller gives some compliance of the confidentiality direction which has to be respected, but if the inventor fails to comply with the provided compliances, their patent may be revoked or cancelled. 7. The invention that falls under the ambit of Section 3 of the Patent Act are not entitled to be patented. 8. Section 57 and 58 of the Patents Act 1970 talk about the permission for alteration of overall specifications of the patent. However, if any inventor utilizing fraud obtains the permission under the mentioned section, their patent comes at a sake where it can be revoked. 9. If an invention lacks originality regarding prior public use or prior knowledge, in such a scenario, the patent can be revoked. 10. In the cases where the inventor gets the invention from overseas and that the invention is already familiar to the public of India. 11. The inventor is bound to reveal the geographical source of the biological material used in the invention. If they fail to reveal the property, they may invite an unnecessary revocation threat. 12. If the invention does not fulfill the standard of Section 21J of the Patents Act, the patent granted on such innovation can be revoked or cancelled. 13. If the invention claimed by the actual invention is already familiar to the local or native community in India. Then comes Section 66, which is the patent revocation in the public interest. Law does not allow any person to be self-centered. That is, if you have something discovered and that something is beneficial for you, but it is harmful to the public at large, or the process via which it gets prepared is harmful to the public at large, the law won't allow you to continue with the discovery. Section 65, which states the patent revocation or alteration of full specification on directions from the government in cases concerning atomic energy. Section 65 of the Patent Act authorizes the central government with the right to ask the appellate board or the controller to cancel the patent of a patent owner and every other individual whose name has been entered or listed or registered as having an interest in the patent if the patent acquired by them deny the subsection 1 of Section 20 of the Atomic Energy Act 1962, 33 of 1962, which states that no patent can be issued if such patent is for an invention concerning to atomic energy. However, the controller may give the patent owner and every other individual whose name has been entered or listed in the register as having an interest of patent an option to make an acceptable alterations which further does not obstruct the subsection 1 of Section 20 of the Atomic Energy Act. Then comes Section 85, that is the patent revocation by the controller for non-working. Section 85 states that when a compulsory license has been issued in relation to the patent, the government or any individual interested may request the controller for an order cancelling the patent on the following grounds. 1. That the patented invention or innovation has not been worked in the boundary of India. 2. The patented invention or innovation is not available to the general public at a logical affordable price. 3. The requirements of the public regarding the patented invention have not been satisfied. Now to conclude the video on an essential note, which is the application to the controller of the government or any individual interested shall be made after the expiration of 2 years from the date of order of issuing the first compulsory license. So that concludes our video on patent revocation. For more such information or queries that you may have, contact Swarit Advisors from the details provided below. At Swarit, we have an excellent team of experts who can assist you as per your legal queries. Now, you can comment down below any of the questions or queries that you may have. For more such videos, subscribe to our channel. Thank you.